She stepped in front of me before I'd taken 10 steps past the gate. Not a question, not a greeting. Just a clipboard held across her chest like a toll booth arm, and a voice that had clearly never been told no.
This is HOA property. You're trespassing. You need to turn around right now.
I stopped. I looked at her. Then I looked at the two men flanking her, one with a phone already raised, already photographing my face, the other standing slightly behind her like furniture. I had not knocked on anyone's door. I had not touched anything. I had walked maybe 30 feet down a gravel access road on a Tuesday morning, and I was being told to leave. She hadn't asked my name, hadn't asked what I was doing. The assumption was total and immediate. I did not belong here, and she was the person authorized to remove me. The HOA owns this land, she said, filling my silence. It was acquired years ago. Whatever you think you're doing it on our property. She said it the way people say things they've never once had to prove. I had a folded envelope in my jacket pocket. I didn't reach for it. She had just told me, with absolute certainty, that I was trespassing on land I had paid inheritance tax on 3 weeks earlier. Her name was Delia Hargrove. She was the president of Crestfield Commons. HOA had been for 11 years, from what I'd gathered. She was standing on a gravel road that ran along the western edge of a 312 home subdivision, flanked by a board member named Voss, who was still photographing me, and a man named Pruitt, who I'd later learn was both a board member and the HOA's retained attorney. She told me she had already called this in to the county sheriff's non-emergency line. She told me that any further incursion onto HOA-controlled property would result in removal. She used the word incursion like she'd been waiting to use it. Voss kept the phone up. I kept my hand still. I asked her one question, quietly. The way you ask something when you already know the answer. Who holds the ground lease for this subdivision? Something crossed her face a fraction of a second, barely a flicker. Then it was gone, replaced by the full return of certainty. The HOA owns this land, she said again. We don't operate under a ground lease. You clearly don't know what you're talking about. She said it with the total confidence of someone who had never once pulled the original title record. I nodded. I looked down at the gravel under my feet. I looked at the entrance gate behind her. I looked at the rows of houses visible in the middle distance, 312 of them, sitting on land I had 3 weeks of paperwork, confirming was mine. Then I said I'd be on my way. I walked back to my truck. I set the folded envelope on the passenger seat. I didn't open it. I just looked at it for a moment. One thing Hargrove hadn't noticed, or hadn't thought to care about, was the small digital recorder clipped inside the breast pocket of my jacket. She had just told me, out loud, in front of 2 witnesses, that the HOA owned land it had never purchased, never been deeded, and never held any recorded title to. She'd said it like a fact. I drove home and put the recorder in the same drawer as the envelope. What Delia Hargrove didn't know, what she couldn't have known, because she had never once pulled the original ground lease, was that the last person to sign a deed on every acre beneath her feet was my uncle. And 3 weeks ago, every acre became mine. My uncle Fletcher Reed was not a complicated man. He didn't talk much, didn't spend much, and didn't sell anything he'd already bought. He had a saying he repeated so often it stopped sounding like wisdom and started sounding like stubbornness. Land doesn't go anywhere. He meant it as a compliment to land. He trusted it more than he trusted most people, and over the course of about 40 years, he let that preference quietly shape his entire life. In 1981, he purchased a 1,500-acre parcel in the county rolling terrain, some timber, some open field, bisected by a creek that flooded reliably every spring, and that he considered a feature rather than a problem. He didn't develop it. He didn't flip it. He paid his property taxes every year and let the land sit, because Fletcher Reed had the patience of someone who understood that the right moment to do something with a piece of ground was never right now. In 1987, a developer came calling. Crestfield Development Corp. wanted to build a residential subdivision on the eastern portion of the parcel, roughly 600 acres of the 1,500. Fletcher wasn't interested in selling, but he was willing to lease. What they agreed to was a ground lease. A ground lease means exactly what it sounds like. The developer leases the land from the landowner, builds on it, and sells the homes, but the land itself never changes hands. The homeowners own their structures. The developer owns the improvements during the lease term. The landowner still owns the ground underneath all of it. It's a common arrangement in commercial real estate, less common in residential subdivisions, which is part of why it becomes invisible over time. The lease term was 35 years, with renewal options that had to be exercised in writing. It was recorded with the county in 1987. Fletcher signed it. The developer signed it. And then everyone more or less forgot about it. Because 35 years feels like forever when you're building a neighborhood. Crestfield Development Corp. built 312 homes over the following years, sold them all, collected its profits, and dissolved as a corporate entity in 2004. When it dissolved, the Homeowners Association Crestfield Commons HOA was formally incorporated to manage the community going forward. Board members were elected, bylaws were written, rules were established, and somewhere in that transition, the ground lease disappeared from institutional memory. I say disappeared because I don't believe every subsequent board member was lying. I think what happened is simpler and more human than that. Nobody checked. The developer handed over the HOA formation documents, the management files, the bylaws, the reserve fund accounts, and the HOA board looked at all of it and believed they were looking at the complete picture. They assumed the land had been dealt with. They assumed ownership was settled. They assumed because nobody told them not to. For almost 2 decades, the HOA operated as if it owned the land beneath 312 homes. Fines were issued, liens were filed, rules were enforced, and none of it was ever tied back to a deed, because nobody ever pulled one. The 3-5-year lease expired in 2022. Fletcher never reached out about renewal. Not because he'd forgotten his files were meticulous, I'd learn, but because, from what I could piece together later, he'd grown ill in 2021 and was gone before the expiration date arrived. He left no instructions on the lease because he likely assumed whoever inherited the land would handle it. That person turned out to be me, and I didn't know any of this existed until I was sitting in a probate attorney's office 3 weeks before Hargrove blocked me on that gravel road. The title search took 11 days. I hired a title company to run it independently. The result came back clean and unambiguous. The 1,500-acre parcel was in my name, transferred by inheritance, with no recorded deed of sale or title transfer to any other party at any point in the chain. I then called the county recorder's office directly and asked a clerk to confirm whether any conveyance from Fletcher Reed or his estate to Crestfield Commons HOA or to Crestfield Development Corp. or to any successor entity existed on record. There was nothing. The land had never left my family. I pulled Fletcher's files next. They were in 3 banker's boxes in the back of a storage unit he'd maintained for 30 years. The 1,987 ground lease was in a manila folder labeled, in his handwriting, Crestfield Development Agreement. It was a 2-page document, county stamped, with the legal description of the parcel, the lease term, the renewal conditions, and 2 signatures on the last page. One was Fletcher's, one was the developer's. The renewal window had passed unopened. The lease was expired. No one from the HOA had ever contacted Fletcher or his estate or anyone. I sat with that folder for a long time. I want to be fair about Delia Hargrove for a moment, because fairness matters to me even when I don't extend it to people who haven't earned it. It is possible, genuinely possible, that when Hargrove first took the board president position 11 years ago, no one handed her a ground lease and said this is what the land situation actually is. It is possible she inherited the same incomplete picture every board before her had inherited. It is possible she believed, sincerely, that the HOA owned the land. What is not possible to excuse is what she did with the 11 years she had. In that time, Hargrove had imposed 47 distinct fine categories. Everything from the approved palette for front door paint colors to the permitted height of mailbox post numbers. She had overseen 4 separate lawsuits against individual homeowners, 2 of which ended in liens that forced families to liquidate savings to keep their homes. She had driven 2 previous board members off the board. One resigned after being publicly accused, in an HOA newsletter, of undermining community standards. The other simply stopped coming to meetings after Hargrove made clear that dissenting votes would be documented and used in future fine assessments. She ran Crestfield Commons the way a feudal lord runs a village. Total compliance expected. Questioning the rules treated as the first evidence of a violation. The fines weren't just about revenue, they were about making sure everyone understood who was in charge. And she had built all of it on land she had never once verified she had the right to control. That morning on the gravel road, when she told me I was trespassing, I wasn't angry yet. I want to be honest about that. I found the situation almost architectural in its absurdity. A woman who had spent 11 years treating 312 households as her personal jurisdiction had just accused the landowner of trespassing. But when I got home and sat down with Fletcher's folder and the voice recorder from my jacket pocket that changed the calculation, she hadn't just made a wrong assumption, She'd made it out loud, in front of witnesses, with a confidence that told me she had never once considered the possibility of being wrong. That was the version of this I couldn't let go. The letter arrived 5 days later. Certified mail. My name spelled correctly, which told me someone had done at least that much research. I signed for it on a Wednesday morning, set it on my kitchen counter, and made coffee before I opened it. Some things are better read slowly. It was 3 pages, printed on Crestfield Commons HOA letterhead, with the association's logo centered at the top, a stylized rooftop above the words, community, standards, excellence. The irony of that third word would keep me company for several months. The letter was a formal trespass notice. It informed me that on the date of my visit, I had unlawfully accessed HOA-controlled property without authorization, in violation of the association's governing documents and applicable state trespass statute. It informed me that the HOA was assessing an unauthorized access fee of $2,400, plus a $500 administrative surcharge for the board's time in processing the incident. It informed me that any further incursion, that word again, would result in a lien filing against any real property I held in the county, and potential civil action for damages. It was signed by Delia Hargrove, board president. Co-signed by Voss, board secretary. I read it twice. Not because I was upset, because I was interested. In 3 pages of formal HOA letterhead, Hargrove had claimed in writing, under her signature, that the HOA owned the land in question. She cited the association's governing documents as the source of authority. She cited her own bylaws. What she did not cite was a deed. What she did not cite was a title record. What she did not cite was any recorded document that transferred ownership of the land from anyone to the HOA, because no such document existed. She had just put a provably false ownership claim on paper and signed her name to it. I set the letter down and thought about that for a moment. There's a particular kind of person who has operated without accountability for so long that the idea of documentation has stopped feeling dangerous to them. They sign things the way the rest of us breathe automatically, without examining what the signature actually means. Hargrove had been running Crestfield Commons for 11 years. In that time, nobody had ever come back to a letter she'd sent and used it against her. That was about to become a problem. I did not respond to the letter. What I did instead was pick up the phone and call a colleague, a title attorney I'd worked with on several transactions over the years, a careful and precise man named Garrett, who had the useful quality of writing his legal opinions the way a surgeon closes an incision. No unnecessary motion, nothing left open. I asked him to run a formal title opinion on the 1,500-acre parcel and deliver it in writing. I didn't tell him why. I didn't tell him what I was planning. I just gave him the parcel number and the county, and told him I needed it clean and documented. He called me 8 days later. "You own it," he said. "Outright. No encumbrances, no competing claims on record, no recorded transfer to any third party at any point in the chain. The ground lease expired in 2022 and was never renewed. You are the landowner of record. Can you put that in writing?" "Already typed," he said. That letter went into the folder with the 1,987 ground lease, the county title search results, and the recording from my jacket pocket. Hargrove didn't wait for a response from me. 12 days after the first letter, a second certified envelope arrived. This one assessed an additional $2,400, doubling the original fee, and added new language about a pattern of trespass, suggesting ongoing and willful violation of HOA property rights. There was a paragraph near the bottom that referenced the HOA's authority to pursue all available legal remedies, which in HOA language typically means a lien and a lawyer. I read that one once and filed it. That same week, I was forwarded a screenshot by someone I'd never met, a resident named Warren, who'd seen my truck near the subdivision and recognized it from a description circulating in the neighborhood. He didn't know who I was. He just thought I should know what was being said. Hargrove had posted in the Crestfield Commons community Facebook group. The post informed residents that the HOA was actively managing a situation involving an unauthorized individual who had repeatedly attempted to access HOA property. It assured the community that legal steps were being taken and that the board was protecting the interests of every homeowner. It did not name me. It was written in the calm, authoritative tone of someone who has run a neighborhood newsletter for so long they've forgotten that words have consequences. I took a screenshot. I noted the date and time. I added it to the folder. I want to describe what the folder looked like at this point, because it matters. It was a standard manila folder, the same kind Fletcher used for the ground lease. Inside it, in the order I'd collected them. The voice recording transcript I'd typed up from the morning of the first confrontation dated, time-stamped, with Hargrove's exact words in quotation marks. Garrett's written title opinion. The first HOA letter with its $2,400 fee and its unsigned ownership claim. The second HOA letter with its doubled fee and its pattern of trespass language. The Facebook post, screenshot, printed with the timestamp visible. 5 items. Each one either directly contradicted Hargrove's position or directly documented her escalation. She was building my case for me, one certified letter at a time. I had still not told her who I was. I had still not told her what I held. I had not responded to either letter. I had not called her, emailed her, or made any contact with the HOA in any form. From where she was sitting, I had walked onto her property, refused to leave willingly, ignored 2 formal demand letters, and gone completely silent. She would have interpreted that silence as intimidation working, as a man who knew he'd been caught and didn't know what to do next. That interpretation would cost her. She'd just sent me, in writing, a formal claim that the HOA owned land my uncle never sold to anyone. I printed 2 copies, one for my files, and one for someone I was starting to think would find it very interesting indeed. I found Warren Calloway, the same way most useful things find you by accident, and then all at once. He'd been the one to forward me the Facebook screenshot, through a number I didn't recognize. I'd thanked him briefly by text and left it there. But 3 days later, he was waiting near the public road that ran along the subdivision's northern boundary when I came by to walk that section of the parcel line. He was a man in his late 60s, gray at the temples, with the careful posture of someone who'd spent a long time trying not to draw attention to himself. He had a coffee thermos in one hand, and the expression of a person who had been wanting to say something for a while and had finally run out of reasons not to. "You're the one she's been sending letters to," he said. It wasn't a question. "I am," I said. He looked at me for a moment, then he said, "How bad is it going to get?" I told him I didn't know yet. That was honest. Warren and his wife had lived in Crestfield Commons for 14 years. They'd raised 2 kids there, paid their assessments on time every single month, and kept their property in the kind of meticulous condition that should have made them invisible to an HOA board. For 11 of those 14 years, they'd been fine. Then they painted their fence. The approved color palette for exterior wood surfaces in Crestfield Commons ran to 11 shades, all variations of white, cream, and what the HOA guidelines called natural neutral. Warren's wife had picked a color from a hardware store that matched the sample card she'd been given. What she hadn't known, what nobody told her, was that Hargrove had updated the approved palette list 8 months earlier without formally notifying residents. The new list had 12 shades. The color on Warren's fence was the one that had been removed. Hargrove sent a violation notice within a week of the paint drying. Warren appealed. He had the old palette card. He had the receipt from the hardware store. He had photographs showing the color matched what he'd been given. Hargrove's response was that the current list governed, that the appeal was denied, and that a $4,200 lien had been filed against the property for continued non-compliance. $4,200 for a fence color that had been approved when they painted it. Warren had been paying it down for 2 years, interest compounding at the rate the HOA set, which was not a rate anyone had voted on. "We looked into fighting it," he said. "The attorney we talked to said it would cost more than the lien to litigate, so we just pay." He said it the way people say things they've stopped being angry about because the anger was too expensive to maintain. Through Warren, I met Joanna Pratt. She was a single mother in her mid-30s, 2 kids in middle school, a job in medical billing that kept the lights on with not much margin for error. She'd bought her home in Crestfield Commons 6 years ago because the schools were good and the neighborhood felt safe. For the first 3 years, it was. Then she missed a $200 assessment payment during a month when her car needed a repair she hadn't budgeted for. The HOA added a late fee. She paid the assessment, but not the late fee, because she didn't realize the late fee existed until a second notice arrived. By the time she caught up with the paperwork, the balance had compounded to $800. She paid it in full. Hargrove's position was that the manner of payment split across 2 months constituted a second late violation, another fee, another notice. 6 months before I walked that gravel road, Joanna had received a letter informing her that her outstanding balance, now $1,400 after 18 months of compounding fees on fees, had been referred for forced sale proceedings evaluation. The letter explained, in careful legal language, that the HOA had the right to initiate foreclosure on a property for unpaid assessments. Over $1,400. She had 2 kids. She had a mortgage. She had been terrified for 6 months. "I didn't tell anyone," she said, when Warren introduced us in his driveway. "I didn't know who to tell. I thought if I talked about it, somehow it would make it more real." I asked her if she still had the letter. She had every letter, every notice, every payment confirmation. She'd kept them in a shoebox under her bed because she was afraid of what would happen if she lost them. I want to be clear about something. I came to Crestfield Commons because Delia Hargrove had told me I was trespassing on land I owned. That was my reason. My ground lease. My deed. My inheritance. That was the thing I was going to resolve. What Warren and Joanna showed me was the context that had been operating underneath that story for years. An entire neighborhood living in low-grade financial fear. People who had learned not to question the rules because questioning was itself a violation. People who had assumed, as the HOA, had assumed that the authority being exercised over them was legitimate, because authority that old and that confident must have been built on something real. It hadn't been built on anything real. It had been built on a ground lease that expired in a banker's box while my uncle was dying. That knowledge didn't change my strategy, but it changed the weight of what I was carrying. Before I left Warren's driveway that evening, I filed a public records request with the county for the HOA's fine collection ledger. Under the state's HOA transparency statutes, associations with more than 100 units are required to make certain financial records available on request. Fine account balances fall within that category. The document came back 10 days later. 114 active fine accounts across 312 homes. 36% of the community carrying outstanding balances. Total amount, $891,400. I ran my finger down the column of addresses. The entry for Hargrove's address board president, 11 years, 47 fine categories, showed a balance of 0. No fines, no fees, no assessments late or otherwise in the entire recorded history of the ledger. Not once. I set the document in the folder next to Garrett's title opinion and the 2 certified letters. The folder was getting heavy. The process server came on a Thursday morning. I was in my kitchen with coffee and Fletcher's folder when I heard the knock. The man at the door was polite, efficient, and handed me a sealed envelope with the practiced neutrality of someone who had learned not to make eye contact during delivery. He was gone before I'd fully closed the door. I set the envelope on the counter next to my mug. I already knew what it was. Not because I'm prescient, but because Hargrove had sent 2 demand letters with no response, posted publicly about an unauthorized intruder on HOA property, and had an attorney sitting on her board who billed by the hour. The next step was never going to be a phone call. I opened it slowly. Some things are still better read slowly. It was a civil lawsuit, filed by Crestfield Commons Homeowners Association, plaintiff, against me, defendant. The law firm on the letterhead was Pruitt and Associates, the same Pruitt who had stood behind Hargrove on the gravel road 6 weeks earlier, phone in hand, ballast in a blazer. He had apparently decided that standing behind her wasn't enough and had graduated to filing on her behalf. The claims were trespass, interference with HOA operations, and a demand for injunctive relief specifically, a court order preventing me from accessing HOA-controlled property in perpetuity. I read that phrase twice. HOA-controlled property, in a court filing, under penalty of perjury. The legal argument was thin but structurally coherent, in the way that a building made of the wrong materials can still look like a building from the outside. Pruitt's theory was essentially this. The HOA had operated as the de facto owner and manager of the land for nearly 20 years, and long-term uncontested operation constitutes a form of ownership. He cited the association's governing documents. He cited the community's continuous residency. He cited something called the 2004 Assumption of Property Rights, a document, he claimed, in which Crestfield Development Corp. Had transferred its interest in the land to the HOA upon dissolution. He did not attach a recorded deed. He did not attach a title record. He attached a copy of the 2004 document itself, which I read carefully. It was a single page, signed by a representative of Crestfield Development Corp. On behalf of a company that had, at the time of signing, already filed for dissolution with the state. It purported to transfer the developer's property rights and interests to the HOA board. It had never been filed with the county recorder's office. A deed that isn't recorded doesn't transfer title. It's a piece of paper that 2 parties signed, and unless it's recorded with the county, it has no legal effect against a recorded title held by someone else. The 2004 document was wallpaper. It looked like ownership paperwork. It functioned like none. Pruitt either knew this and was hoping I didn't, or he had built his entire legal theory on a document he'd never bothered to verify. Either way, it was going to be a problem for him. I set the filing on the kitchen counter and looked at it for a long moment. There is a specific clarity that arrives when something you've been quietly preparing for. The weeks of title searches and folder building and county records requests, all of it had been anticipatory. I had known something was coming. I hadn't known exactly what shape it would take. Now I did. Hargrove had handed me the exact venue I needed. A private property dispute, a matter between a landowner and an HOA that had forgotten to verify its own foundations, had just been walked into a public courthouse and placed in the record. Every document Pruitt filed would become discoverable. Every claim Hargrove had made verbally on that gravel road would now need to survive scrutiny under rules of evidence. She had taken something she could have quietly resolved and made it permanent and public. I appreciated that more than I could say. I made 3 phone calls that afternoon. The first was to a licensed surveyor, a meticulous man named Donovan, who had done boundary work for me on 2 previous transactions, and understood that when I said certified and stamped, I meant every word. I gave him the parcel number, the legal description from the 1,987 ground lease, and told him I needed a current survey showing the full 1,500-acre boundary with the Crestfield Commons subdivision overlaid. I needed it to show, precisely and irrefutably, that every home, every road, the community center, the entrance gate, and the gravel access road where Hargrove had confronted me, sat within the boundary of the parcel I'd inherited. He said he could have it in 3 weeks. The second call was to the county courthouse, where I filed a notice of representation. I would be representing myself in the civil matter. My bar number went on the filing. My name, my credential, my contact information, all of it entered the public record quietly, the way most important things enter records. Without announcement, without drama, processed by a clerk on a Tuesday, and filed in a system that doesn't care about the weight of what it's holding. The third call was to the county recorder's office, where I requested a complete certified copy of every conveyance, every recorded instrument, every lien, every encumbrance, the full history, certified and stamped. What came back confirmed what I already knew, but now I had it in the format a judge could hold in her hands. The first hearing was scheduled for 41 days out. I printed that date on a piece of paper and taped it to the inside of the folder. Below it I wrote, in Fletcher's kind of handwriting, deliberate, unhurried, a short list. Ground lease 1,987 recorded. Title record no transfer on file. Deed of inheritance recorded. Survey pending. 2004 assumption document unrecorded. No legal effect. 5 lines. The entire architecture of what was going to happen in 41 days, written out like a grocery list. I looked at it for a moment, then closed the folder. Hargrove had sued me for trespassing on my own land. She'd done it through an attorney who had been standing on that same land the morning she'd ordered me off it. She'd done it in a courthouse where, it turned out, 3 of the clerks in the real property division had attended continuing education seminars I'd taught the previous spring. None of them knew what was coming. Neither did she. Delia Hargrove had just sued me for trespassing on my own land and filed it in a courthouse where, it turned out, 3 of the clerks had taken real property law seminars I'd taught the previous spring. The notice went out 2 weeks before the court date. Emergency Community Meeting Crestfield Commons. HOA. All homeowners. Strongly encouraged to attend. The stated purpose, according to the HOA's community calendar, which was publicly accessible, which was how I received a copy, was to brief residents on an external threat to the association's land ownership and the steps being taken to protect the community. I marked it in my calendar. I was, after all, a member of the public. The meeting was listed as open. The bylaws Hargrove herself had written required that open meetings be accessible to any individual with a legitimate interest in HOA business. I had what most people would consider a fairly significant interest in HOA business. I ironed a shirt. I showed up 10 minutes early. The community center at Crestfield Commons was a low, wide building near the entrance, beige siding, HOA approved of course, with a parking lot that held about 60 cars and a main room that could seat roughly 100. By the time the meeting started, 74 homeowners had filled the chairs. More were on a Zoom link projected on a screen at the front. The room had the compressed, slightly electric feeling of a space where people had come expecting to be told what to think and were ready to comply. Hargrove stood at the front with a portable podium and a laser pointer. She had prepared slides. The first slide was a timeline of the HOA's history and incorporation in 2004, 20 years of community management, infrastructure maintained, property values sustained. The second slide was a photo of the entrance gate, the community center, the streets of Crestfield Commons. The third slide said, in large, confident font, "Our community, our land, our rights." She told the room that an unnamed outside party had been making unauthorized attempts to access HOA property and had been issued formal trespass notices. She told them that the HOA had retained legal counsel and filed suit to protect the community's interests. She told them that the association's ownership of the land was ironclad, her word, used twice, and that this matter would be resolved in the HOA's favor within weeks. She did not mention the 1,987 ground lease. She did not mention that a ground lease had ever existed. She did not mention that the land had never been conveyed to the HOA by recorded deed. She spoke for 22 minutes with the easy fluency of someone who had never once been interrupted by a fact. I sat in the back row and listened. The room was with her. I want to be honest about that. 74 homeowners in a community center, 2 weeks before a court date, being told by the person who had run their neighborhood for 11 years that an outside threat was being handled. Most of them nodded. Some took notes. A few glanced around the room with the mild, reassured expressions of people who have outsourced their worry to someone more confident than themselves. Hargrove saw me about 20 minutes in. I know because she paused barely, a half beat when her eyes crossed the back row. Then she continued. She didn't address me. She didn't point me out. She recalibrated in real time and kept going, which told me she was either very controlled or very practiced. Probably both. What she couldn't recalibrate was what happened next. Warren Calloway raised his hand. He was sitting about 6 rows from the front, next to his wife, and he raised his hand the way someone does when they've decided the cost of not asking is higher than the cost of asking. Hargrove acknowledged him with the tight-lipped courtesy of someone who has learned to manage dissent by appearing to welcome it. "Has the HOA produced a recorded deed to the land?" Warren asked. "Not the governing documents. An actual recorded deed from the county." The room shifted slightly. Not dramatically, just the small collective adjustment of people who have heard a question they hadn't thought to ask themselves. Hargrove said the deed was in the legal file and that it wasn't relevant to the purpose of tonight's meeting. Warren nodded slowly and sat back. That answer in the legal file was not the same as, "Yes, it exists." I suspected Warren knew that. I suspected at least a few people in that room knew it too. Then a younger woman, 3 rows from the back, raised her hand. I hadn't seen her before. She had the alert, precise manner of someone who reads documents carefully before signing them, a quality I've always found underrepresented in HOA settings. Her name, I'd learn later, was Sloan Merritt. "Does the HOA carry title insurance on the land?" she asked. Title insurance is what you purchase when you close on a property, to protect against a competing ownership claim that surfaces after the fact. If the HOA had title insurance, a competent insurer would have verified the title before issuing the policy. If they didn't have it, that was its own answer. Hargrove said the question was outside the scope of the meeting. Sloan Merritt wrote something in the small notebook she was holding and said nothing further. The meeting closed 35 minutes after it started. In her closing remarks, Hargrove said in the careful, measured tone she used when she wanted something to sound like a fact, rather than an opinion, that the HOA was dealing with what she described as a predatory land speculator attempting to steal from this community. She said it clearly. She said it into a room of 74 homeowners and a Zoom link and the HOA's own recording equipment, which ran automatically per the bylaws she had written. I wrote it down, the exact phrase, the date, the time, the room. Then I stood up, nodded to no one in particular, and walked out. In the parking lot, I sat in my truck for a moment with the windows down. The October air was cooling fast, and the lights in the community center were still on, and I could hear the muffled sound of chairs scraping and people filing out, normal sounds. The sounds of a neighborhood that had just been told, by someone it trusted, that everything was fine. A knock on the passenger window. Warren, his wife behind him, hands in her pockets. I rolled the window down. "That thing she said," Warren started. "Predatory land speculator." "I heard it," I said. She said it into a microphone. "The meeting's recorded." "I know." He looked at me for a moment. Then he said quietly, "Who are you, exactly?" I reached into my jacket pocket and handed him a business card. Then I handed one to his wife. Then, because Sloan Merritt had appeared behind them with her notebook still in her hand, I handed one to her as well. My name, my bar number, my title, licensed real estate attorney. Warren looked at the card for a long moment. Then he looked at me. Then he looked back at the community center, where Hargrove was still visible through the window, standing at the front of the room, talking to Pruitt with the satisfied posture of someone who believes they have just managed a situation. He didn't say anything. He didn't need to. I started the truck. She'd called me a predatory land speculator into a live microphone in a recorded meeting. I drove home, set the recording date in my notes, and thought, 22 days. The morning of the hearing, I woke up at 5:30 without an alarm. I made coffee. I opened the folder. I read through everything once, in order, the way you read something not because you've forgotten it but because you want to carry it correctly. Then I closed it, put on a jacket, and drove to the courthouse. I got there 40 minutes early. The clerk at the Real Property Division window recognized me from the seminar, a woman named Patricia, who had asked 3 excellent questions about title chain documentation and remembered details better than most attorneys I'd worked with. She didn't say anything about the case. She just nodded, handed me my filed copies, and said, "Courtroom C. Judge Okafor." I thanked her and found a bench in the hallway. Pruitt arrived 20 minutes later with a rolling briefcase and the slightly elevated color of a man who had eaten a working breakfast. He saw me on the bench, registered something not quite surprise, more like recalibration, and nodded once with the professional courtesy attorneys extend to each other when they'd prefer not to. Hargrove came in behind him. She was dressed formally dark blazer, the kind of careful presentation that signals someone who wanted to be taken seriously in a room where seriousness is measured. She walked past me without making eye contact. Voss followed her, one step behind, still functioning as ballast. In the gallery, because the hearing was a civil motion in an open courtroom, I saw Warren Calloway and Sloan Merritt take seats in the second row. They had come on their own. I hadn't asked them to. Warren met my eyes briefly and gave a small nod. Sloan had her notebook. Judge Okafor took the bench at 9:02. She was a compact, unhurried woman with the quality I've always respected most in judges. She read everything before she spoke, and she asked questions that made clear she had read it. She'd had the filings for 2 weeks. She had Pruitt's complaint, his exhibits, and my response packet submitted 5 days earlier, which contained the 1,987 ground lease, the certified title chain, the deed of inheritance, and Donovan's survey. Pruitt went first. He was competent, which is the most dangerous kind of wrong. He laid out the HOA's position in clear, organized language. 20 years of continuous operation, 20 years of community management, 20 years of treating the land as the association's own. He argued that the 2004 assumption of property rights, which he submitted as Plaintiff's Exhibit A, constituted a valid transfer of the developer's interests to the HOA. He argued that the HOA's uncontested operation over 2 decades established its authority beyond reasonable dispute. He spoke for 14 minutes. He used the phrase community reliance 4 times. He did not produce a recorded deed. When he finished, Judge Okafor looked at his exhibit stack for a moment. Then she looked at me, counsel for the defendant. I stood up. I didn't use notes. I didn't need notes. Your Honor, I said, the plaintiff's entire case rests on a single document. Plaintiff's Exhibit A, the 2004 assumption of property rights. I'd like to address that document directly. I submitted my exhibit packet. 3 documents, tabbed and labeled. Tab 1, the 1,987 ground lease. County recorded, county stamped, with the legal description of the parcel, the 3-5-year term, the renewal conditions, and 2 signatures on the last page. I read the recording information into the record instrument number, book, page, date. It took 30 seconds. This is the document that governs the land relationship between my family and this subdivision, I said. It was recorded with this county in 1987. It has never been superseded by any recorded instrument. Tab 2, the certified title chain. Every recorded document in the chain of title for the 1,500-acre parcel from 1,971 to the present. I held it up. It was 43 pages. I would direct the court's attention to the absence of any recorded conveyance from Fletcher Reed or his estate or any successor to Crestfield Commons HOA or to Crestfield Development Corp. Or to any other party. The title chain is unbroken. The land has never been sold. It has never been deeded to anyone. Tab 3, my deed of inheritance, recorded with the county 8 weeks ago. My name, the parcel description, Clean title, no encumbrances. I am the landowner of record, I said. I have been since the date of recording. I paused. The room was very quiet. Plaintiff's Exhibit A. The 2004 assumption document was signed by a representative of a company that had already filed for dissolution. It was never recorded with the county recorder's office. Under state real property law, an unrecorded instrument has no legal effect against a recorded title held by a bona fide owner. The document is not a deed. It has never functioned as one. I set the exhibit packet on the plaintiff's table, in front of Pruitt, so he could look at it. Then I sat down. Judge Okafor looked at the packet for a long moment. She turned to tab 1. She read the recording information. She turned to tab 2. She spent 40 seconds on the first page of the title chain, the way someone does when they're verifying rather than discovering. She turned to tab 3. Then she looked at Pruitt. "Counsel," she said, "does the plaintiff have a recorded deed to the land in question?" The courtroom went very still. Pruitt opened his briefcase. He looked through the top folder. He looked through the second folder. The sound of paper in a quiet courtroom is remarkable. Each page turned precise and audible, and somehow getting louder as the silence around it deepened. "Your Honor," he said, "I'd like to request a brief recess to confer with my client." 5 minutes, she said. Hargrove and Pruitt moved to the far corner of the courtroom. I didn't watch them directly. I watched the gallery. Warren Calloway had both hands flat on his knees. Sloan Merritt had stopped writing. Voss was looking at the floor with the expression of a man trying to remember if he'd signed anything. The 5 minutes felt like a weather system passing through. When Pruitt returned to the table, he stood for a moment before he spoke. He had the careful posture of someone choosing his next words, the way you choose footing on uncertain ground. "Your Honor," he said, "the plaintiff is prepared to acknowledge that a title dispute exists, and that further documentation may be required to establish the HOA's ownership position." Judge Okafor looked at him for exactly the length of time it takes to make clear that an answer has been heard and evaluated. "The plaintiff's motion for injunctive relief is denied," she said. "The trespass claim is dismissed with prejudice. The defendant's recorded title stands uncontested on this record." She said it the way judges say things when they've been reading documents all morning, and the documents have already told them everything they need to know. I let one beat pass, then I stood. "Your Honor, one additional matter. As the landowner of record for the parcel underlying Crestfield Commons subdivision, I am providing formal notice of new ground lease terms to the plaintiff, effective immediately." I handed Pruitt a second document across the table. Hargrove, seated directly behind him, reached forward instinctively, and Pruitt let her take it. I watched her read the first page. The 1,987 ground lease had been structured at a rate that reflected 1,987 land valuations modest, developer-era numbers that had made sense when the parcel was undeveloped farmland at the edge of a growing county. The new rate was 5 times that figure, recalculated against current assessed land values, consistent with comparable ground lease rates in the county for similar parcels. It was my legal right, as the landowner, to set those terms. The HOA had 30 days to accept, negotiate, or face a demand to vacate the land. Hargrove read the first page, then the second. Her face went through several things in quick succession: confusion, then calculation, then something I can only describe as the specific expression of a person watching a door close that they did not know was open. She looked up from the document. She looked at Pruitt. He was reading his copy with the focused attention of a man who has just understood that the building he was standing in is made of different materials than he thought. She looked at the gallery. Warren was looking back at her. Sloan was writing. She looked at me. I was already gathering my folder. The room, as I walked out, was very quiet. The kind of quiet that has weight. The kind of quiet that arrives after something has been settled that cannot be unsettled. In the hallway, Patricia, from the records window, was walking past with a stack of files. She glanced at me briefly. "Courtroom C?" she said. "Done," I said. She nodded once and kept walking. She had called me a predatory land speculator 2 weeks ago in a recorded meeting. Today, in a courthouse where her lawyer couldn't produce a deed and a judge had dismissed her lawsuit in under an hour, she had read the terms of a new lease on land she had never owned. The deed had always been in the envelope. She just hadn't known whose name was on it. The HOA's new attorney called me 19 days after the hearing. Not Pruitt. Pruitt had quietly withdrawn from the board within a week of the courtroom, a resignation submitted by email, no explanation given, no farewell to the community he'd co-signed 2 demand letters on behalf of. The new attorney was a straightforward woman named Reed who had apparently been retained specifically to resolve the situation without further litigation. She had read the file. She did not waste either of our time. "My client would like to accept the new ground lease terms," she said. "The 30-day window is still open," I said. "They'd like to move faster than that." We had the paperwork executed in 4 days. The new ground lease agreement was recorded with the county on a Thursday afternoon. Instrument number, book, page, date, my name as landowner, Crestfield Commons, HOA, as tenant. The 2004 assumption of property rights was formally declared null on the same record. It had never been a deed. Now it was officially nothing. I was in my kitchen when the recording confirmation came through by email. I read it once, set my phone down, and finished my coffee. The legal resolution was clean. The financial fallout was not. The new ground lease rate, 5 times the original, recalculated against current land values, represented a significant increase in the HOA's annual operating costs. That increase had to come from somewhere, which meant it had to come from assessments. The board called an emergency financial meeting to explain to residents why their annual dues were going up and why the reserve fund they'd been paying into for 2 decades was suddenly insufficient. That meeting did not go well for the people running it. Sloan Merritt had, in the 3 weeks since the hearing, done what people with precise minds and small notebooks tend to do when they've been told something important. She had researched. She had pulled the HOA's financial disclosures required under state statute, available on request, and had spent several evenings with a spreadsheet. What she found was that for the past 4 years, a portion of the fine revenue collected from residents had been directed not into the reserve fund or the operating account, but into a discretionary account that required only one signature for withdrawal. Hargrove's signature. The account contained $214,000. Sloan filed a formal complaint with the state HOA regulatory board the same week. The complaint was accompanied by the fine collection ledger I had obtained. The one showing 114 active accounts, $891,400 in outstanding balances, and Hargrove's own address, carrying a 0 balance across the entire recorded history. The regulatory board opened an investigation within 10 days. Hargrove was removed from the board by a community vote before the investigation concluded. The vote was not close. Warren Calloway was elected to fill her seat. He called me the evening after the election not to celebrate, just to tell me, the way someone tells you something they want witnessed. "It passed," he said. 71-3. I told him that was a good number. "Joanna cried," he said. At the meeting, when they announced it, I said I understood. The new board voted, in its first formal session, to audit every fine issued under Hargrove's tenure against the HOA's own documented violation records. Any fine that lacked documented evidence of the underlying violation, a photograph, an inspector's report, a written notice that predated the fine was voided. 61 of the 114 outstanding accounts were cleared. Joanna Pratt's balance, the $1,400 that had been compounding for 18 months, the number that had kept her awake with a shoebox of letters under her bed, was among them. I know because Warren told me, and because Joanna sent me a short text that said only, "Thank you. I don't know how else to say it." I wrote back that she didn't need to say anything else. Warren's lien, $4,200 over a fence color that had been approved when they painted it, was also voided. He and his wife repainted the fence the following spring. The same color. Nobody sent a notice. The HOA's recording of the community meeting, the one Hargrove had run 2 weeks before the hearing, the one in which she had called me a predatory land speculator into a live microphone, was submitted as supporting documentation in Sloan's regulatory complaint. The investigator noted it in the file as evidence of Hargrove's pattern of conduct toward parties who challenged her authority. I had written down that phrase the night she said it. Date, time, room. It turned out to be worth writing down. I drove out to Crestfield Commons on the morning the new lease was recorded. I parked on the gravel access road, the same spot, the same stretch of ground where Hargrove had planted herself in front of me with a clipboard and told me I was trespassing. I got out of the truck and stood there for a minute with my hands in my pockets. The entrance gate was open. The morning was clear and cold, the kind of November morning that makes everything look like it was recently cleaned. I could see the rows of houses from where I stood, 312 of them, quiet at this hour, lights on in a few kitchens, a dog walking a man down the sidewalk in the middle distance. I thought about Fletcher, about 3 banker's boxes in a storage unit and a manila folder labeled in his careful handwriting, about a man who bought land in 1981 and never sold an acre of it, who trusted it more than he trusted most things, and who turned out to be right. Nobody came out to stop me. No clipboard. No phone raised for photographs. No one to tell me I didn't belong on the ground I was standing on. I stood there until the cold started to work through my jacket. Then I got back in the truck, set the folder on the passenger seat one last time, and drove home. I've been asked, since then, whether I feel any satisfaction about how it ended, whether the X5 rent, the investigation, the vote, the voided fines, whether any of it felt like what I was after. The honest answer is that I didn't set out to become anyone's landlord. I set out to walk a boundary line on a Tuesday morning, and got told I was a criminal for doing it. What I wanted was simple, and I think, reasonable. I wanted the person who had looked me in the eye on my own land and told me, with absolute certainty, that I had no right to be there. I wanted her to have to say, in writing, in a courthouse, under the signature of a judge, that she was wrong. She had to say it. The record says it permanently. That's enough. The last thing I heard was that Delia Hargrove had put her house on the market. Her house, of course, sits on land. She now has to pay me 5 times more to stand on than she did the morning she blocked a gravel road and called me a trespasser. I didn't set out to become anyone's landlord. But I've always believed that if you're going to make a claim in writing, you'd better be able to back it up. She couldn't. I could. The deed was always in the envelope.